Alors, on va commencer notre débat. Et comme première, j'ai déjà dans mon liste Monsieur le Président Bertrand Mathieu. Très bien. Alors, je vous en prie.
Merci beaucoup, Monsieur le Président. Je voudrais déjà remercier Simina Donacescu d'avoir organisé cette rencontre qui est très vivante et très intéressante. Je voudrais revenir sur le problème de la séparation des pouvoirs. Je crois qu'en effet, la question budgétaire est une illustration extraordinaire de la manière dont évolue la répartition des pouvoirs. Alors, je ne parle pas, puisque ça sera le thème de demain, de la répartition des pouvoirs national, international ou supranational, où déjà c'est assez complexe, puisqu'on a l'intervention d'organes intergouvernementaux, on a l'intervention d'organes indépendants et on a l'intervention d'organes privés, comme les agences de notation. Mais si on prend simplement sur le plan national, on a un débat qui est finalement extrêmement intéressant entre les rapports entre le pouvoir politique et le juge. Rapport entre le pouvoir politique et le juge, les décisions budgétaires sont a priori des décisions éminemment politiques. Et on s'aperçoit, en entendant notamment les débats, les interventions de cet après-midi, on s'aperçoit que le juge constitutionnel est finalement assez réticent à intervenir dans un contrôle approfondi. C'est un contrôle, en général, superficiel. Mais à partir du moment où il y a des règles constitutionnelles, ça veut dire que le juge constitutionnel établit de lui-même une hiérarchie entre les règles constitutionnelles. On dit que toutes les règles constitutionnelles se valent, mais ce n'est pas vrai. Le juge établit une hiérarchie entre les règles constitutionnelles parce qu'il va finalement assurer un contrôle plus faible de la règle budgétaire que d'autres règles. Le contre-exemple, et il a été cité, le contre-exemple, et je ne porte pas de jugement de valeur ici, ni en bien ni en mal, le contre-exemple, c'est la Hongrie, où ce n'est pas le juge qui hiérarchise, mais c'est la Constitution qui établit une hiérarchie. On peut contester cette hiérarchie, là n'est pas l'objet de mon propos, mais de dire qu'en fait, pour éviter que le juge hiérarchise, c'est le constituant lui-même qui intervient pour hiérarchiser. On a parlé de la France ce matin, et je suis désolé, je n'ai pas pu être là, mais je ne vais pas en revenir, d'autant plus que les intervenants étaient beaucoup plus qualifiés que moi. Mais quand on regarde, par exemple, la règle de la sincérité budgétaire, cette règle de la sincérité budgétaire, elle se joue à trois. Elle se joue entre le Parlement, qui théoriquement décide de la loi, entre le Haut Conseil des finances publiques, qui est un organe indépendant, et entre le juge constitutionnel. C'est-à-dire que le Parlement vote la loi de finances, le Haut Conseil va vérifier que les prévisions économiques, grosso modo, du gouvernement sont sincères, et le Conseil constitutionnel va contrôler. En fait, qu'est-ce qui se passe? Le Conseil constitutionnel ne contrôle rien. On est dans un rapport entre le politique, une autorité indépendante et le juge, un rapport à trois. Et le Conseil constitutionnel ne contrôle rien, puisqu'il dit qu'en fait, il interprète la règle constitutionnelle comme obligeant le gouvernement à ne pas avoir l'intention de créer un de ne pas respecter la sincérité. Il sera très difficile pour un juge constitutionnel de dire que non seulement le gouvernement ou le Parlement ne sont pas sincères, mais qu'en plus, ils n'ont pas l'intention de l'être. C'est une condamnation quasiment morale et donc quasiment impossible. C'est presque une condamnation pour fraude, l'intention. Donc on s'aperçoit finalement que le jeu interne entre le politique et le juge n'a pas fondamentalement changé, mais, et c'est ce qui sera traité demain, le jeu se joue entre les contraintes internationales et les contraintes nationales. c'est-à-dire un affaiblissement considérable du national. Mais je crois que c'est pour les constitutionnalistes, et je remercie encore Simina d'avoir organisé ce colloque, pour les constitutionnalistes, c'est un exemple extraordinaire de voir comment aujourd'hui la séparation des pouvoirs évolue. Merci.
Merci, Monsieur le Président. Cesare, l'autre président, cette fois la Cour constitutionnelle.
It's very interesting to know which is the relation between the political power and the judicial control. Thank you. It's very interesting to discuss about the relation between the political power and the judicial control in the budget, because historically during the war between France and Germany in the 19th cycle, there has been a refusal of the German Diet to pass another budget to buy more machine guns. But the Chancellor Bismarck required to Paul Lavant, the crown jurist, to report about the possibility that the executive power could pass a reform of the budget, and it was passed by the executive power and obtain more budget to the war. I think that's very interesting because in this situation, the tension between the political power and the judicial control is very interesting. In this sense, Daphne Barak has posed one decision, and I would like to ask if in Israel the Supreme Court has competence to control the budget of parliament or executive requirements about budget of the more weapons, for example. The control is only by the form or not by the content of the decision to approve more budget for the weapons. And the question is the only control, do you have used the political question doctrine to, in certain issues, to prefer the decision of the parliament, of the executive, in the decision of the increase the budget for the weapons, if there is case, or don't you have that doctrine of the political question when the Supreme Court refused someone material that is no judicial instrument of the control, like in the increase of the budget for the weapons in the conflict, like is in Middle Orient? No, that's. Thank you.
Thank you. Yeah. Sure.
I will try to answer now before, we get to other comments, and I want to make sure that I fully understood the question, and I will start by saying, and this may be the test whether I get your point, is that in Israel in general, although theoretically we recognize the idea of political question doctrine, there is something equivalent to this in our system, the approach of the court to this doctrine is very narrow. So it is rarely being used. It's not that it's not in existence, but in principle, it is rarely being used. Something has to be very, very extreme in order to be the subject of the political question doctrine, or judiciability as we prefer to call it. And the doctrine was, when it is being used, and as I said, relatively rarely, it's more in areas of war and peace, issues like that, and less in, I would say, economic context. It is true that when the court deals with economic matters, it tries to maybe limit the scope of its discretion, but this is in the stage of, I would say, the way this discretion is being used, rather than saying on from the start that this is not subject for judicial discussion.
Thank you. Other comments, questions? Eric?
Oui, je voudrais juste rajouter deux éléments peut-être simplement, des idées qui sont venues là. Pour ce que nous avons vu cet après-midi, nous apercevons que la règle d'or en réalité dépasse le cadre de l'État, tout simplement. Nous avons, d'ailleurs c'était la volonté du colloque de montrer que Tout le monde est concerné, que ce soit au niveau local, au niveau de l'État, au niveau des autorités aussi indépendantes ou autorités ou agences de l'État, qui en France, par exemple, est assez énorme, puisqu'on a quand même à peu près 50 milliards d'euros de dépenses, rien que pour ces agences. Bon, donc évidemment, il y a un problème d'équilibre. Donc ça, c'est une première réflexion. Les déficits publics sont visés en droit européen, c'est-à-dire tous les déficits, et la sécurité sociale que j'oubliais, qui est aussi évidemment très importante. Voilà. Deuxième remarque, la règle d'or, à mon avis, la première règle d'or que nous avons connue, 1687 peut-être de mémoire, c'est Standing Order du Parlement anglais, la Chambre des communes, qui limite l'initiative financière des membres du Parlement. Nous connaissons tous cette irrecevabilité financière. Elle est constitutionnalisée parfois, parce que le droit d'amendement étant constitutionnalisé, les seules limites sont de niveau constitutionnel, et elle marche. Elle marche. Aujourd'hui, la dérive des dépenses publiques, à mon avis, n'est pas, et des recettes d'ailleurs, n'est pas liée au Parlement. Le Parlement est limité. Et c'est en fait le pouvoir exécutif qui, par son initiative, pratiquement, son monopole législatif dans le domaine des lois de finances, dans le domaine budgétaire, a accru les déficits publics de deux manières, en augmentant les dépenses publiques, là je parle pour le cas français, mais je crois que ça s'applique un peu dans beaucoup d'autres États, en augmentant les dépenses, en diminuant les impôts. Et comment expliquer ce phénomène? Finalement, c'est comment dire, la superposition à notre vieille tradition historique de séparation des pouvoirs, un exécutif, un législatif, peut-être un judiciaire, ça dépendra, ou un juridictionnel, ça dépendra des traditions trialistes ou dualistes de la séparation des pouvoirs. Mais à cette division historique, c'est calqué, ce que disait le doyen Favoreux d'ailleurs, une division politique, c'est-à-dire un bloc majoritaire. Et là, il n'y a plus de séparation des pouvoirs. C'est-à-dire que l'initiative financière d'un gouvernement, elle est relayée par un Parlement qui est de la même majorité politique. Et du coup, la règle d'or maintenant, je trouve qu'elle s'applique plutôt, elle s'adresse plutôt à l'exécutif qu'au législatif. En fait, ce sont les gouvernements qu'on veut limiter. Est-ce que nous ne pourrions pas réfléchir à une méthode qui consisterait à limiter aussi l'initiative gouvernementale? Et est-ce que c'est pas pour la séparation des pouvoirs, en tout cas, la question qui nous est posée avec cette règle d'or à nous, constitutionnalistes? Voilà, les remarques que je voulais faire. Merci.
Merci. So, yes, please.
Thank you very much for your presentations. I would like to make a comment concerning subnational debt from the point of view of what is currently being discussed in Mexico. Mexico is a federal system, or has a federal system, and both federal and state governments are allowed to borrow money for different purposes. However, in recent years, scandals related to high levels of indebtedness in some states linked to accusations of corruption of governors has triggered a debate on how to put limits on the capacity of states to incur public debt. Currently, we are discussing, not we, Congress, the Mexican Congress is discussing or considering 6 bills. These 6 bills, I would say, share the same diagnostic of the situation that we are facing. Part of this diagnostic includes points like the following. There is no common definition of what is productive public investment. And this concept is important because the Constitution says that states can incur debt only for that purpose, for productive public investment. That's the concept. And the problem is that each state understands in a different way what's the meaning of this concept. Another problem is that there is no cap on the capacity to incur debt of state governments. It all depends on the criteria of the local legislature, which is usually controlled by state governors. Here we have a problem of lack of true separation of powers at state level, at the level of the state constitutions. There is lack of transparency, both at the level of the process of contracting debt and at the level of the use of the resources derived from loans. And even in some states, governors can incur debt directly without the approval of the local legislature. So some of the ideas or some of the proposals to face these problems say that what we have to do is to reform the Constitution in order to grant Congress the power to give rules on subnational public debt. That is, we need a federal statute for the regulation of subnational debt, and for having that federal statute, the Constitution has to be reformed, granting the Congress the power to pass that kind of statute, which would have several goals. For example, the goal of establishing uniform rules, principles, and definitions, which today are like dispersed or fragmented. They are very different from comparing one state with the other. For example, a common definition of what is to be understood by the concept of productive public investment, to have a common definition of that, to have common definitions of what is public debt, common definitions of the different types of public debt, and maybe establishing caps, specific caps on the capacity of government, of states governments to incur debt. Part of the proposal also has to do with the definition of who authorizes borrowing. State legislatures, maybe yes, state legislatures, but by a qualified majority of 2/3 of the state legislatures, or even another proposal says that not the state legislature, but the Senate as the federal chamber should be allowed or should have the power to authorize or not indebtedness at the state level. Finally, part of these proposals, or some of these proposals, say that we should have what they have called a national system of public debt. This national system of public debt would include a sort of forum or national council of public officers, federal and local, in charge of public debt, who would define, for example, good practices, or exchange information, or coordinate in everything which is concerned with the management of public debt at the federal and at the state level. This system would include something like a national registry of public debt, and make it public for the sake of transparency. And this system would also produce indicators, to produce sort of alarms when one or some states are producing problems connected with public indebtedness, which could have a systemic impact. Also, and this is my final point of describing this possible federal statute on subnational public debt, there will be duties of transparency on the justification of borrowing, the use of the resources that come from loans, the duty to inform periodically on these matters. Thank you.
Thank you very much. Any other comments? Yes, Marcello.
Well, just to add, I'm sending for Jose Maria from Mexico just a quick comment or remark. As said, Brazil faced quite the same problem. I'm not sure if we are more advanced or not in this issue, but the Federal Senate have a lot of regulations, 2 or 3 resolutions that I'm sending to you, exactly concerning this field. The Senate has the duty or the private competence to establish the maximum limit of debts of the states in Brazil. So maybe this could be useful. That's all. Thank you.
Thank you. Javier?
Yes, in the Spanish experience, there has been a big difference between municipality and autonomous communities, let's say our provinces or states, no? Because the Constitution and the organic law which develops and concretize the Constitution impose municipality full equilibrium. So they cannot have either deficit or public deficit, no? So that produced a huge amount of cuts in many local competences. For instance, municipalities have no competence at all in immigration. But if you have 30 or 40% of immigrants in your municipality, it's nonsense to expect the local government not to act, to integrate those immigrants. So those programs related with competences that we call not strict competences have been retailed and cut, used to find this equilibrium that the organic law and the Constitution following the fiscal compact impose. No? And I would say that the big retails that we have reached have been done by the local governments, with a lot of efforts, because they don't have political autonomy to reach new taxes, everything that has been explained before. On the other hand, the autonomous community share the deficit between the state and the autonomous community, and it's extremely difficult to reach agreements how to find individual objectives and general objectives to share this deficit between the several government and different autonomous community with a political direction completely different from the national one. That's our difference between municipality and autonomous community. I don't know if it is useful outside.
Thank you. Well, maybe now we will ask all our rapporteurs, of course, if they wishes to do so, to react. Professor Justice Barak.
Well, maybe I'll just add a word or two on the issue of the vertical analysis, because it was raised in a very substantive manner after I was presenting. So I would like to say that maybe just to add this perspective also on the case study I was dealing with, and say that there are much harsher measures that can be taken with regard to a budgetary imbalance on local government level. So in this sense, the structure is very hierarchical, and I will just give one example that budgetary imbalance on the local government level in Israel may serve, may be a cause to, I would say, decide that a new local unelected council will be authorized to deal with local government matters rather than the elected officials by the local community. So the central government is very harsh on budgetary gaps on the level of local government law, and maybe the extent of the powers that is given to, maybe I'll add here also a historical, a comment with some historical perspective, that these, I would say, very significant powers that central government in Israel has is also connected to the fact that the local government law in Israel is still the product of British mandate in Palestine. I mean, you may know that we inherited the British colonial system that was in the ground when Israel was established, and later on it was replaced one law after the other, but local government law was still not replaced. There are many proposals for a new municipalities bill, but the result is that we are still dealing with a very old law that obviously gave a lot of power to the central government, because the central government at the time was colonial, whereas local government was not colonial, obviously. So at least for the time being, for these historical reasons, the powers of central government with regard to budgetary issues of local government are very significant. I don't think it will change substantively, but obviously we need a new local government law, and this is not something that I say, but there are many bills that were being proposed, and we are waiting for them to be passed.
Thank you. Mr. Bielov.
I would like just to say a couple of words provoked by Professor Oliva. I also agree, and if I have had some more time, I would also demonstrate in the presentation that we're observing kind of reversed logic in controlling the public finance management, which is quite reversed from the way this has been done in the 19th century. Because in the 19th century, as the Honorable Judge from Peru has mentioned, the fight was how can we pacify the government, how can we control democratically the government through parliamentary control devices, how can we parliamentarize the budgetary and financial process. And now we are observing a great skepticism from the European and the national constitutional legislator on the issue whether the parliaments are sufficiently reasonable and sufficiently democratic and sufficiently representative. And there is an obvious attempt by the national constitutions to reverse the controlling trend, namely to impose some structural limits on the financial power of the parliaments with view to future generations, with view to foreign creditors, with view to the European Union, with view to local governments. And I think this is an indicator, a symptom of a broader problem, of a more abstract problem, namely the issue of deparliamentarization and crisis of parliamentary democracy. And one last remark, we are observing also reversed logic in terms of relationship state-civil society when it comes to accountability and control, because the fight in the 19th and the 20th century was how can the civil society develop sufficient instruments in order to obtain information, control the government, and make it transparent. And now the problem is to some extent reversed in the context of global governance. How can the state, or not necessarily the state, the European Union, the public power, regain to a certain extent its controlling potential towards the emerging army of private actors which are trying to transform their private power into a public one. So I believe the attempt with the budgetary councils is to some extent an attempt to compensate the lack of information and evaluation capacity of the state when it comes to public finance management, because otherwise this task will be done, for example, by the rating agencies. And then we can imagine what will happen with the financial sovereignty of the state if it is let alone to the rating agencies. So that's my remarks.
Thank you very much, Professor.
Indeed, at the local level, you have always the balanced budget rule in the law, but it refers only to limited issues, to the budget provisions, which means that when you make the budget, when you prepare the project, the draft budget, you take into account some projections, and then you dimension the expenditures on these projections, and you will have to provide at the local level for a balanced budget in terms of projections. So if your projections are not correct and you estimate that your resources will be higher than they will actually be, and then you put inside the budget expenditures according to the optimistic projections, you may end up during the execution in a deficit because you signed the contracts at the beginning of the year, and then during the execution, when you have to pay, you discover that you have not cashed enough money to make the payment. So you face up having a deficit. And the problem is, how do you cover this deficit? You are not allowed to borrow for paying this money. So probably if you will end up not paying them. But these areas will accumulate, and you will have to include them in the next year budget. And Romania has seen the situation whereby there are certain local communities which, when are preparing their budgets, are covering their entire projections for resources with arrears, with payments, outstanding payments coming from the past years. So there is no place left for current functioning expenditures. So the balanced budget rule applies only to the functioning section. For the investment section, you don't have a balanced budget rule. You merely have a limited deficit because the law allows you to borrow for the investments, but you have a limited cap on this borrowing depending on your ability to produce enough own resources. So at the end of the day, despite the balanced budget rule, you may, which is enshrined in all national systems, I think, you may end up with a huge problem of local government's deficit that you will have to solve somehow. And unfortunately, there are only two possible or three possible ways of solving this problem. Raising the local tax, which probably will be the least used option. The other way would be to raise more loans, which again the state will oppose because it doesn't want to end up paying for the loans of the local authorities, again despite existing no bailout clauses. And finally, the only solution, practicable solution, would be transfers from the central budget. And you end up with the question, will these transfers limit the local autonomy? Because if this will be the case, then you end up damaging a basic constitutional principle. And this is how the balanced budget rule starting from being a good principle on the good side, ends up having bad effects on traditional constitutional principles. And this is the danger we have to avoid. And I think that here the legislator has to be imaginative enough to understand these dangers and try to avoid them.
Thank you. Professor Iancu.
I'm not a financial law specialist, but from a constitutional standpoint and the EU constitutional standpoint within our bigger jurisdiction, one is very skeptical about the treaty and its implementation. Now, just look at the facts. Miguel Maduro went to the UI and said, now, who imagines that this, according to the treaty, to the Article 3, Paragraph 2, who can imagine that this would be a sort of eternity clause like in the German constitution, Ewigkeitsklausel? Then, and he meant it as a joke, but then Chancellor Merkel came and said that that's exactly what she meant, that it should be introduced in an eternity clause similar to Article 79, Section 3 of the German Grundgesetz. Now, is this what happened? No. In France, you have ordinary legislation, the constitution, ordinary legislation in Romania, the Conseil Constitutionnel has validated this. In Slovenia, you have the rule in the constitution, but no enforcement mechanism. In Spain, you have constitutional entrenchment, but as I understand, the application of the rule is postponed until 2020. No? Just for...
According to the treaty, but not in practice.
So,
reality works.
the only country which seems to have, ironically, incorporated these rules both in the constitution and at the institutional level is Hungary, where this was done in order to hurt the political opposition if they would come to power, most according to both commentators. No? They create a political institution which, under the guise of a formal restriction, will block future budget laws and the execution of the budget. So one can be very skeptical about, we don't know what is the rule, how it will be implemented, through what institutional mechanism, and of course, what will it produce.
Thank you. Monsieur le juge, est-ce que vous voulez ajouter quelque chose? All right. So, I'm not going, of course, to try to resume this discussion. One or two observations. One is that what we have is now quite dense system of legal regulations dealing with balanced budget, or rather with the idea that budget should be relatively balanced. And those regulations deal with all possible aspects, vertical, horizontal, etc., etc. While they may be quite useful in some situations, I still have sometimes an impression that they are, to some extent at least, based on a constitutional optimism. Namely, number one, on the assumption that if something is regulated on the constitutional level, this is sufficient to secure a sound economy, which is not always the case. And usually the problem is that economy is not ready to follow constitutional rules because it may have its own rules which are superior to what is written in the constitutional document. And this may be one problem. And the other is what already was observed in the first intervention of Bertrand Mathieu, namely the problem of sanctions. Constitutional judges are careful in intervening into budgetary problems. Those are political matters, whatever we call it, whatever name we give to this position of self-restraint. Still, this is a dangerous ground, this is a slippery ground, and the price may be very high, and then the Constitutional Court may be held responsible for a budgetary collapse of the state. So the problem of enforcement may be a little bit problematic, which makes, of course, this area more complicated. But what I would suggest for the end, particularly raising this suggestion with Simina and to organize another round table, what we have not discussed today or tonight was the situation in which those mechanisms of balanced budget finally would not function, and the budget collapses. And then we have the bankruptcy of the state, which is, as we well known, I think Argentina experienced it already twice. It's not impossible, and it happens. So the problem is, what is the constitutional framework for a bankruptcy of the state? Are there any constitutional rules? Are there any experiences? Rules, I'm not sure. Experiences, surely. And then the other question is, what about supranational limitation of bankruptcy? Now, if someone is in the Schengen zone, there is even no way to be bankrupt, because then another mechanism would apply. So we may have a quite rich and interesting set of problems to resume our discussions next year or in 2 years, only if Simina's budget will not collapse until that time. Thank you very much. Thank you for all these presentations, for all interventions. This was a particularly rewarding afternoon. And now I suppose Professor Tănăsescu will say
just a
something
short
more
mention
interesting
on
to us.
logistics. Tomorrow we will see on the international regulations, because the tomorrow session is dedicated to other approaches to the economic, philosophic, and international approach. So part of your questions will be answered tomorrow, but only part. You're right about Argentina. I just wasn't able to find somebody in Argentina. Secondly, for the logistics, thank you very much to those who were
who are located in other hotels, but I do apologize in advance. The bus will leave in front of the Hotel Siqua, which I presume most of you now know. The bus will leave at 6:30. So now you have free time available for you. But at 6:30, a bus will be downstairs in front of Siqua, and it will pick us all and take us to the restaurant. It's downtown in the center. If you want to come by foot, you have, or otherwise, you have the address in the file. If you want to come by foot, it's like 30 minutes walk. Up to you. See you later then. Thank you. Și mulțumesc frumos pentru traducere.